The privilege against self-incrimination is an important matter that you need to be aware of if acting for a party who is called to give evidence at a coronial inquest. In Petty and the Queen, the privilege against self-incrimination was described in this way. A person who believes on reasonable grounds that he or she is suspected of having been a party to an offence is entitled to remain silent when questioned or asked to supply information by any person in authority about the occurrence of an offence, the identity of the participants, and the roles which they played. That is a fundamental rule of the common law which, subject to some specific statutory modifications, is applied in the administration of the criminal law in this country. An incident of that right of silence is that no adverse inference can be drawn against an accused person by reason of his or her failure to answer such questions or to provide such information. To draw such an adverse inference would be to erode the right of silence or to render it valueless.
A leading case in Australia in relation to claiming privilege against self-incrimination in coronial inquests is the case of Crown and the coroner. That case involved the deaths of Douglas and Isabel Wilson, who were suspected to have been murdered by members of the drug ring they were allegedly associated with. Mr. Brian Alexander was a managing clerk employed by a criminal law solicitor's firm, and he sought to invoke the privilege in circumstances where he'd been previously charged with conspiring to pervert the course of justice in respect of the murders and had declined to cooperate in an interview with police. Although he had not been committed for trial, an ex officio indictment was still possible at that time. When Mr. Alexander was called to give evidence at the inquest, his senior counsel objected to him being compelled to give evidence on the basis of the privilege. The Chief Inspector assisting the coroner argued that it was important the coroner not be frustrated by persons who refused to give evidence, and that there needed to be real danger or reasonable ground to believe the answers would in fact incriminate Mr. Alexander. The coroner required Mr. Alexander to answer the questions, and the matter was put before Justice Gray of the Victorian Supreme Court. On hearing the matter, Justice Gray held that Mr. Alexander could not only be compelled to answer questions that would incriminate him, but also answers which tended to incriminate him. His Honour rejected the proposition that it was only when specific answers were given to questions put to Mr. Alexander that the privilege could be invoked. Mr. Alexander was therefore entitled to the operation of the privilege. However, Justice Gray accepted that a witness claiming privilege does not automatically invoke it, and the court is bound to form a judgment as to whether the claim is bona fide and has substance.
This issue arose in Decker and the State Coroner of New South Wales. Decker was a geologist. He claimed privilege against self-incrimination in respect of the deaths of 18 persons in a landslide at Thredbo. He had been involved in the planning and major geotechnical work in the area in which the landslide occurred. The coroner allowed Decker to invoke the privilege. However, on appeal to the New South Wales Supreme Court, Adams J held that the coroner was not obliged to apply the provisions relating to self-incrimination as contained in the New South Wales Evidence Act, and that to do so would be inappropriate. As a result of the decision in Decker, a series of amendments were made to coronial legislation throughout Australia to allow coroners to compel witnesses to give evidence and to provide them with protections similar to that provided in the evidence legislation.
There is presently no uniform coronial legislation across Australia, and so the legislation in Queensland varies from other jurisdictions in the country. In Queensland, the relevant provision that relates to incriminating evidence in the Coronial Act is Section 39, and that relevantly holds that the coroner may require the witness to give evidence that would tend to incriminate the witness if the coroner is satisfied that it is in the public interest for the witness to do so, but that evidence is not admissible against the witness in any other proceeding other than a proceeding for perjury. Thus, a coroner in Queensland can compel a witness to give evidence notwithstanding the fact they've invoked the privilege against self-incrimination in circumstances where the coroner believes that it's in the public interest to do so. And in those circumstances, the evidence that the witness gives can not be used against the witness except in proceedings for perjury.
Derivative evidence is not admissible in criminal proceedings. However, derivative evidence will be admissible in civil proceedings such as a claim for personal injuries. Similar provisions exist in other states. In those circumstances, coroners should not compel a witness to give evidence unless it is in the interest of justice to do so, or the public interest requires it.
There are several matters that the coroner is required to consider when determining whether a witness should be compelled to give evidence where they've invoked their privilege against self-incrimination. And these considerations include the significance of the potential prejudice to the witness, including criminal or disciplinary action that might arise as a result of their evidence, the extent of the protection, if any, that would be extended to the witness if they were to give evidence, the necessity of the evidence, whether it goes to a central issue for determination in the inquest, and whether other evidence is available to the coroner to satisfy this purpose, whether the evidence is intended for the findings or for the coroner's recommendations and comments, and finally the reliability of the evidence overall.
With respect to the prospect of claiming privilege for a witness who is going to give evidence at an inquest, it is important to make a determination about that point early on, or at least as soon as possible. One would not want to be making a claim for privilege on behalf of your client unless it was absolutely necessary to do so. The result might be that you come under the attention of the coroner in circumstances where he or she did not otherwise think there was any particular issue in relation to what your client did in the circumstances of the case. A decision to claim privilege against self-incrimination therefore requires a thorough knowledge of the circumstances of the case, including your own client's involvement in the case, and a full and frank discussion with your client about the potential implications of making such a claim. Of course, if there is a need to claim privilege against self-incrimination, that should be done, but it should not be a decision made lightly or simply undertaken as a matter of course.
If privilege against self-incrimination is to be claimed, it's important to tell the witness how this is to be done, and it's also beneficial to inform the coroner and counsel assisting that this witness seeks to claim that privilege, so that any argument against that claim can be had before the substantive proceedings are undertaken. And it's also important to remember that the claim against self-incrimination isn't necessarily only against your oral evidence or in respect of oral evidence of a witness, but also the written statements made in submissions to the coroner in the course of or at the end of the inquest.